No, we haven't got now. I was waiting for the special red button. We now have it. All right, council, this is our third session of the Kansas Court of Appeals today on January the 10th, 2022. The case that we have on for this third session is case number 123420 in the matter of Bank of Commerce and Trust Company Incorporated versus Banccentral National Association Incorporated. Today, I have the honor of serving with Judge David Bruns of the Court of Appeals, who has been on the court since 2011, and Judge Sarah Warner, who has been on our court since 2019. My name is Kim Schroeder, and I have been on the court since 2013. I have the honor of presiding as being the presiding judge. Mostly, my job will be to keep track of time. This matter is set for 15-minute arguments. After I ask to make your appearances, I'll ask the appellant to tell me whether or not he would like to reserve what he wants to reserve for rebuttal. So with that, counsel, I'd ask you to enter your appearances.
James Long appears on behalf of the appellant, Bank of Commerce and Trust Company.
May it please the court, Martin Ufford on behalf of the defendant appellee, Banccentral.
Thank you. I think, Mr. Long, you're the appellant. You may proceed.
Yes, if possible, I would like to reserve 5 minutes for rebuttal.
10 and 5.
May it please the court, counsel. This case stems from the appellee's removal of a Diebold ATM, an antique Cannonball safe from the First National Bank building in Harper, Kansas. The issue before the district court was the legal basis in which the appellee claimed an ownership interest in these items. At the time of their removal, the appellee was a tenant of the building. Neither the ATM nor the Cannonball safe had been installed or placed in the building by the appellee. They were not the appellee's trade fixtures. The Diebold ATM was a substitute for an earlier NCR ATM that had been replaced by an earlier tenant of the building, Bank S&B.
So was the replacement with the permission of the landlord?
No, it was not. There is an affidavit in the file that indicates that the landlord at the time, the Oliver Trust, was not aware of the fact that the NCR ATM was being replaced with the Diebold ATM. The NCR ATM was placed in the building by the owner of the building, the First National Bank of Anthony. This will later have some significance. The antique Cannonball safe had been in the building for decades. To remove the Cannonball safe, the appellee had to tear out the vault frame and door. Based on these facts, appellant asserts that the district court erred in its rulings.
Mr. Long, before you go, Mr. Long, I hate to interrupt you, but before we get too far into it, let's talk about the Cannonball safe. You say that was put in decades ago,
Yes.
correct?
Yes.
Okay. Does it make a difference whether it was a fixture or personal property as far as who owned it?
It would not make any difference unless the appellee in this case had raised an issue that the Cannonball safe had been abandoned. But in this case, that argument was never raised at any point of the proceeding.
Okay, and I think you're anticipating probably where my next question, which is, does a tenant, unless it's in the lease agreement, have a right to remove personal property
Uh,
that was already there when you take possession.
Exactly. You're getting exactly to my point. The Van Ness versus Picard case indicates that under common law, a tenant or an individual that finds property on a leasehold would not be able to remove that property. That's basically common law going back to the early 1800s.
Okay, so go ahead. I just went because I know there's some argument about whether the Cannonball safe's a fixture or not, and at least right now that seems immaterial. But Mr. Edford might tell me otherwise. So
Well,
you may proceed.
And I'd like to direct answer that with the following. Basically, the appellant's argument in this case is that the resolution of this appeal rests on two legal principles. One, that as a general principle of fixture law, it is presumed that when the owner of the item is the owner of the realty, permanent accession to the freehold was intended. In this case, when the Cannonball safe was placed on the premises decades ago, it was by the owner of the premises at that time, which would have been the First National Bank of Harper.
Counsel, that's a little bit misleading in that the owner, there was a unity of interest at that point, right? So there wasn't a tenant, that the owner was in fact the same entity that was operating the bank.
Right. There was not a tenant until the FDIC closed the bank in 2009. So the items that were placed on the property before 2009 were done by the owners of the building, which is the point of my first point is that fixture law, under common law fixture law, it is presumed that when the owner of the building is placing property on the realty, it is intended as a fixture. And that in the citations that I have, the legal arguments are found on page 17 of my brief, opening brief.
Counsel, I have a question about the finding that the district court made with regard to annexation. And I wonder if we can talk about that. It sounds like the district court was particularly focused on the perceived mobility since this Cannonball safe was on wheels,
Yes.
and put a lot of stock in that fact. If we were to disagree with the district court's annexation conclusion based on that fact, where does that leave us? If we determine that we have to analyze fixtures for purposes of determining ownership of this safe, and we make the conclusion that the district court's annexation finding wasn't supported by the evidence, can we then reach a conclusion as to whether this is a fixture, or is that something that is fact-based that has to go back to the district court?
No, I don't think it's fact-based given the facts of this case. You know, regardless of whether it was on wheels, it couldn't have been removed from the vault without tearing out the vault frame and vault door. Whether this case is analyzed under the strict attachment argument that is being made by the appellee, or a constructive fixture attachment argument, it would be nevertheless attachment under the third part of the fixture test.
Well, and here's my question is that we've got this three-part test with regard to fixtures: annexation, adaptation, and then the intent of the parties. If we only have a finding as to annexation, are there other facts in the record by which we can reach the conclusion on parts 2 and 3, or are there not?
I believe that there are, as I indicated previously, it is presumed that when these items were placed on the premises, that they were intended to be permanent accessions to the realty, which would satisfy the most important criteria of that three-part fixture test. The second criteria is the adaptation to the use of the property to the realty. In this case, there wasn't any real dispute that the Cannonball safe was put on the premises for the purposes of operating a bank establishment. It had been there for decades.
So in essence, it was a safe inside a safe.
Excuse me?
I said, in essence, it was a safe
didn't hear
inside
you.
it was a safe inside a safe.
Yes, it was a cash safe inside of the vault.
Well, I mean, the vault's a locked door, which is kind of a safe, right?
That is correct. I think they had a different term for it decades ago. And I'm trying to recall what that term was. I think it was some sort of, I guess the term is just vault, but you're correct. It was a separate place within the vault to store the cash.
All right.
The second principle that I believe the district court did not address, and I feel probably it's because it's a case of first impression for this court, is the substitute fixture test dealing with the Diebold ATM that was substituted for the NCR ATM that was in the building at the time the FDIC closed the First National Bank of Anthony and
So
sold
can
it.
I ask a question about the ATMs? As
Correct.
I understand the record, the ATM was not attached to the building.
Well,
But bolted down. It might have been held, it might have been sealed with a little bit of caulking on the outside for weather, but there was no permanent attachment. Is that correct?
again, it gets back to the presumption that when an item is placed on the freehold by the owner of the property, it's intended to be a fixture. If you take an analogous situation, you have beds in hotels that are considered fixtures. Lamps in hotels are considered fixtures. Paintings in hotels are considered fixtures. They're not attached per se to the hotel room, but they're nevertheless considered fixtures of that particular business.
Council, what are we to draw, if anything, from the fact that when the FDIC transferred this to Banccentral's previous or predecessor, that it included in those transfer agreements automatic teller machines?
It did not include an automatic teller machine from the FDIC to Bank SNB or Bank of Anthony.
So it was only Bank SMB to the Banccentral that included the automatic teller machine?
It generally referenced it in the purchase and assumption agreement. That's correct. But in the list of assets to that agreement, they did not specifically list the ATM machine as being transferred to the appellee.
Council, I've allowed you to exceed your time. Unless one of the other judges have questions, I'll ask you to wrap up.
Just to cut to the chase, even assuming arguendo that these items were not fixtures, it still doesn't, under the Van Ness versus Picard ruling, the personal property found on the freehold would nevertheless be property of the owner of the freehold. And I believe because there wasn't any other claim of abandonment in the case, the issue that the district court never reached is on what theory but the appellee became the owner of these items. Thank you.
Counsel, your response?
May it please the court, again, this Martin Ufford on behalf of the defendant appellee, Banccentral. After a 2-day bench trial, Judge McQuinn found the Cannonball safe to be personal property and not a fixture, and that Bank of Commerce failed to meet its burden of proof that it was the owner of the property. We believe the following preliminary principles apply to this case. First, whether a piece of property is a fixture is a question of fact. Second, so long as there is substantial evidence in the record to support the trial court's finding the Cannonball safe was not annexed to the F&B building, this finding should be affirmed, and this court should accept as true the evidence and all inferences to be drawn therefrom, which tend to support the findings of the trial court. Finally, to prevail on a conversion claim, plaintiff has the burden of proof to establish it is the owner of the property in question. It is not the defendant's burden to prove it is the owner of the property.
Well, counsel, answer this question.
Yes, sir.
How is it not a fixture if it required substantial damage to the building in order to remove the safe?
Well, Your Honor, we contend the evidence establishes there was not substantial damage to the building, which should be inferred from the finding of the trial court. If you look at what I believe is Exhibit 13, and I can confirm that, there was basically an invoice for the cost of repairing or to reinstall the vault frame and door, and the items listed that actually pertain to putting the frame back in the hole where it was removed and patching up the sheetrock and bricks was less than $5,000, and the balance of the $8,000 bill was for items such as transporting the vault frame and door from a storage shed back to the building, which had nothing at all to do with the damage to the building itself. And
Counsel, was it possible to remove the Cannonball safe without removing the antique vault door and door frame?
Your Honor, I believe the evidence was it had to be removed to get the safe out of the vault.
And did the district court take that into consideration at all? Or because as I read the district court's ruling following the trial, it appears that it is based solely on the fact that this Cannonball safe was on wheels.
I believe there is something we cited in the brief to the effect that the judge said, I understand you had to take the vault door and frame off, but once that was done, it was easily rolled out of the vault room itself, Your Honor.
Well, isn't that the equivalent of saying, yeah, I understand that you had to blow up one of the walls of the building, but once that wall was blown up, it was really easy to get that out, right?
Well, Your Honor, the key is, was there material damage to the building? And first of all, there's no evidence in the record whatsoever that any structural engineer testified the building was unsafe or structurally damaged by the removal of the safe. And the bank's president himself admitted, and that his testimony was admitted as part of the evidence in the case, that he never consulted with a structural engineer about this building. So we contend, especially given construction costs today, that a bill less than $5,000 is almost minimal in today's world as far as construction costs are concerned. And the building would be in exactly the same condition it would have been had the door not been removed. And I made this argument in our brief and at the trial court. This is sort of like somebody who buys a pool table and wants to put it in their basement, and it won't fit around the corners inside of the house. So you have to remove a window in the basement to squeeze it through, and then you put the window frame back in and everything's fine. I don't think the pool table in that case would be considered a fixture or part of the house.
But a pool table A pool table can be taken apart and moved in pieces. This safe could not be taken apart.
Your Honor, I would say to some extent that is true, but if you have a regulation size snooker table with a full slate, you're not going to want to cut that slate to squeeze it around a corner in your house.
Well, my experience has been they come in sections and are put together, but that's the question to me is how is the removal of anything in the building to get the safe out not damage to the building?
Well, Your Honor, I think that's a critical distinction. That is exactly what the plaintiff is arguing, that any damage to the building results in a finding that the disputed item is a fixture, not personal property, whereas our appellate courts have said, no, it's a much tighter standard. It's material damage to the property. That's maybe a matter of a difference of opinion between various finders of fact. But again, given I submit a relatively insignificant amount, the fact that this was just cosmetic damage to the building that could easily be patched over, that we haven't reached that material damage threshold.
Did the district court make a finding to that effect?
I don't think the court made a finding on the material damage issue, Your Honor.
I want to ask you the same question that I asked your opposing counsel, Mr. Efford, and that is, if we disagree with you, and if we were to conclude that there's not substantial evidence in the record to support the district court's finding with regard to annexation of that Cannonball safe, where does that leave us?
Well, even if if you dispute the court's finding on annexation, there's still the issue of adaptation of the item for the particular use of the property. And there is no evidence whatsoever that the structure of the Cannonball safe was modified in any way from when it was first put in the building 100 years ago to the present time. And therefore, it was not adapted for the use to the building to which the test is to which it is connected, which I would submit is almost back to annexation.
Is that a legal conclusion that we can draw from the facts that were presented to the district court?
No, Your Honor, I think it's part of the 3 tests for factual finding that an item in dispute is personal property or a fixture. And we also have evidence in the record that there is a nearly identical Cannonball safe sitting in the hallway of the Harper County Courthouse just outside the treasurer's office, which would indicate these safes are used for a variety of purposes in addition to safekeeping property belonging to the customers of a bank. The county treasurer obviously used that safe to safeguard valuable property or money in its possession when that safe was used for safekeeping in the county courthouse.
Mr. Efford, just a real kind of simple, I think, question to make sure I understand. We've kind of speculated as to some of the things that maybe the district court ruled or didn't rule or thought or didn't think. Since this is a civil case, aren't we completely controlled by whatever's written down in that journal entry of judgment that was filed with the clerk of the district court?
I think between that and the transcript of the court's ruling, which was incorporated by reference, I'm assuming that would be it, Your Honor.
Okay, so it was, I mean, I didn't see that, but you're saying the transcript was incorporated by reference into that? Well, either it is or it isn't. We can look at it, but you think it was?
I believe it was. I think I prepared that, and I normally, when there's a court's ruling, incorporate it by reference, so I don't have to recite everything that the judge said. Good.
That's good practice. I just didn't see that in here because I was looking at paragraph 1, I think it was, and Judge Warner, I think, was referring to it, where the real finding seems to be the safe sets on wheels and was rolled out of the vault easily after the vault door and frame were removed. So in any event, it is what it is, but you would agree that generally in a civil case, the journal entry controls, but if it incorporates a bench ruling, it can, but if it doesn't, then the bench ruling is pretty much immaterial.
I think so, Your Honor.
We're in a criminal case. It's just kind of the opposite. But anyway, okay. Thank you.
Your counsel, your client was a tenant of the bank and bought some of the assets in the bank from the previous tenant?
That is correct, Your Honor. It was basically the assets used in the banking business.
All right, and is the Cannonball safe identified in that contract?
No, it is not, but Your Honor, if I can refer to another contract, which I think is also very pertinent to this case, the contract between the FDIC and the Sally Olivier Trust specifically provided that any personalty that may be owned by the seller that is situated on the property at closing will be conveyed to the purchaser by a quitclaim bill of sale. And no quitclaim bill of sale was offered by the plaintiff to establish its ownership of that safe. And if they had produced such a bill of sale, well, we would not be here today. Obviously, that would have resolved this issue. And we contend that if they want to rely on that contract to form the basis for their ownership in the safe, if the Cannonball safe, or for that matter, the ATM, well, I'll just stick with Cannonball safe, is personal property, then there's no bill of sale. So then you look to the abandonment issue. And if I may address that briefly, since counsel did address that. First of all, in Kansas, abandonment can be raised simply by a general denial. You don't need to plead abandonment as an affirmative defense. And second, the law in Kansas is that whether or not a piece of property has been abandoned, you have to look at the facts and circumstances of the particular case and who first exercised dominion or control over the abandoned property. And in this case, the evidence is undisputed that there is no evidence that FDIC used that safe in any manner after the banking assets were conveyed to Bank SMB. And there's also no evidence that FDIC or the Sally Olivier Trust used the Cannonball safe after the building was conveyed to the trust in 2011. Instead, the evidence is undisputed that Bank SMB used the Cannonball safe for safekeeping of its business customers until it replaced the safe to get a more modern safe that it could tie into its security system automatically. So if you look
again, we don't have any finding by the district court to that effect, though, do we?
Your Honor, I think at this point, as long as we're talking about findings, as I raised in my brief, the appellant's brief doesn't address anywhere where the court made any of the findings it complained of or where it raised any of the issues.
That's fine, and I understand where your beef is with the state of the appellant's brief, but I'm talking specifically about this abandonment issue. The district court never made any findings regarding abandonment.
That is correct. And if you want to look at de novo, I don't think there's any evidence that would support the issue that it wasn't abandoned. It was clearly abandoned. Given who used it, there is evidence as to who used the safe and who didn't during the time in question.
Anything further, counsel?
Your Honor, if I may just look at my notes real quickly.
You may.
See how much time I've expended. Whoops, got a couple of minutes.
Counsel, if I may,
Yes,
while you're kind of gathering your thoughts, I wonder if you could give me some preliminary thoughts as to why the ATM in a nutshell is not a fixture.
well, okay, first of all, the plaintiff itself admitted that the ATM was not attached to the building in any way. And for that, just a second. On pages 3 to 5 of our brief, Your Honor, I cite to the record numerous facts that were submitted as uncontroverted in our summary judgment memorandum that the plaintiff admitted, and turning in particular to fact number 8 to read it in its entirety. This particular machine did not have any anchor bolts holding it to the floor. A plastic lid was placed between the exterior west wall and the part of the Diebold ATM that extended through the hole in the west wall. Then silicone caulking was used around the edges to protect the interior of the building from the evidence. And this is the key sentence. The Diebold ATM itself was not attached to the building in any way. The plaintiff admitted that fact, Your Honor, and I think that addresses the annexation or attachment issue right away. Also,
out of curiosity, counsel, does it matter that the ATM was supposed to be bolted down and it wasn't in this instance?
well, I think in this case, it was heavy enough where it didn't need to be bolted to be moved. The fact of the matter is it was not attached. And speaking of attachment, there's also testimony from the plaintiff's bank president that he did not see any way the Cannonball safe could have been attached to the building either. It was just sitting on the floor and we had gravity working to keep it in place. I don't know if you want to talk about the amenities issue, but the fact that the Martin's Company appraisal prepared exclusively for the FDIC refers to the Cannonball safe as an amenity, we think is totally irrelevant to this case. An amenity is basically something tangible or intangible that enhances the enjoyment of a piece of property for the owner. We argued that, for example, an ocean view can be considered an amenity, and therefore amenity is not the equivalent or synonymous with fixture, and therefore the reference to amenities in the appraisal is irrelevant in resolving this dispute. I think, judging by the questions all the court has asked, you're well familiar with our arguments in my brief, and I don't believe I have anything further to say. Thank you.
Any other questions? Thank you. Mr. Long, your rebuttal.
Yes, Your Honor. I'd like to make 4 points. Number one, I am not aware of any Kansas case or any case at all that addresses material damage outside the context of a trade fixture installed by a tenant. I have never heard of a situation where a tenant can cause damage, material or otherwise, to remove an item that is not a trade fixture of the tenant. Second, the point is made that there was never any quit claim bill of sale produced in this case. However, the appellant did produce the affidavit of the trustee of the Sally Oliver Trust, who testified it was her understanding that the Cannonball safe and ATM had been purchased by the original purchaser of the building, the Oliver Trust. So even though we've been unable to secure the bill of sale from the FDIC, we were able to secure the affidavit of the original purchaser of the building, who indicated that the NCR ATM and the Cannonball safe were part of the purchase of the building. With respect to the third point, the abandonment issue, I understand that Mr. Ufford is making the argument that it can be raised as a general denial. However, abandonment was never raised as any issue in the pretrial conference order. It was just something that was not addressed, nor was it even part of the trial for that matter. Lastly, the last point Mr. Ufford makes is that plaintiff's appellant counsel admitted that the Diebold ATM was not attached. That may be true, but what we're focusing on is the original ATM that was in the building, which was the NCR ATM. There was never any evidence indicating that it was not attached before they replaced it with the Diebold ATM.
Counsel, was there any evidence that when that happened, when the NCR ATM was removed and the Diebold ATM was installed, that there was a request to the trust to pay for the new ATM?
There was never any request. It was, to my understanding, from the affidavit of Mr. Schroeder, the original NCR ATM was sold by Bank SNB on the secondary market. And that purchase, those monies, I'm surmising, were used to pay for the cost of the Diebold ATM that it was replaced by.
Let me ask you a real general question, but we need to know this. What specific relief are you asking for here?
I am asking for the district court to be reversed and for a finding that the appellee committed conversion in removing the Cannonball safe and the Diebold ATM from the First National Bank building in Harper. I believe,
but I take it if we did that, do we throw out the entire journal entry, or do we keep part of it because they didn't appeal, or do we send the whole thing back to the district court, or do we just reverse without remand?
Well, I believe there's sufficient facts in the record that I went through initially in my remarks.
Well, I'm just trying to figure out what you're asking us to do. Bottom line, we always have a conclusion paragraph and a bottom line of what we do. What do you want us to do?
Yes, bottom line, the case needs to be reversed, and there needs to be ultimately a finding that there was conversion in the removal of these items.
Okay.
For the simple reason, as I outlined in my opening remarks, that it is a presumption in the law that when items are placed on a freehold by the owner of the realty, that those are intended to be fixtures. Point number one. And point number two is any fixture that is removed and replaced with another fixture falls within the substitute fixture rule and cannot thereafter be removed. Thank you.
Thank you, counsel. I appreciate the arguments today. I do have one question of curiosity. What is the value, and it has nothing to do with the case, but being an antique safe, what is the value of this safe?
It's an interesting question for the building, for the First National Bank building of Harper. It happens to represent a historic value. It's been in the building for decades. If you were to go and try to replace it on trying to buy one, I think they retail, depending on the condition, anywhere from $6,000 to $12,000, somewhere in that range, depending upon, of course, the condition and things of that sort.
No problem. It was just a curiosity question, and I didn't recall seeing it anywhere than what I've read. So thank you. We appreciate the arguments. They've been well presented. We'll take the matter under advisement and issue an opinion as quickly as time allows. Have a good day.
Thank you.
Thank you both.